Hello and welcome to LLFtv's Video Landlord Advocate. This segment will cover one of our core topics. That core topic for the next few months is going to be lease management. We're going to cover varying topics regarding lease management for the next few months. And today we're going to specifically talk about leniency. We're going to talk about, some people call it compassion, some call it enabling, some call it bad business practice, some call it this is customer service. Whatever you want to call it, I'm going to call it leniency for purposes of this conversation. And I'm talking about not enforcing the lease that you've got in place. Allowing people to commit lease violations, perhaps even not pay their rent on a timely basis, and the impact it might have on your ability to manage the property, as well as manage the folks who are living on your property. Leniency basically sends two messages. It sends a message to the community and it sends a message to the courts when you ultimately decide to change your policy. And I want to talk about both of those a little bit. First one is the message it sends to your community. As you know, the one common denominator that we are absolutely aware of, that every one of your residents has, is you. They may be friends on the side, they may know other people in the community, but they absolutely have a relationship with you, and it's defined in that lease. The reason that's important is because the way you handle one particular individual is absolutely going to be the talk of the town, it's going to be the talk of the community, it's going to be the scuttlebutt at the water cooler that is going around the community. And if you are ignoring somebody's illegal animal, if you are ignoring somebody's excessive noise issues, if you don't take any action after there's police involvement in a unit, or there's a dispute between residents that turns into something a lot more significant than perhaps just an argument, how you handle that is what people are going to see and what they're going to talk about. And so when the question in their mind comes up, well, do I need to do X? Do I need to comply with this provision of the lease? Do I need to answer the notice or the request from my landlord? They're going to push the boundaries. And that's just human nature, and it's something you should expect, but it's also something that you can prevent based on how you handle situations on the property. And so what message do you want to send to the community? Do you want to send one of leniency, one of, you guys can do what you'd like to do, and if it ultimately gets me upset enough or is disturbing enough to the neighbors, then we will enforce it? Or do you want to send a message, hey, you've got a lease, it explains what the expectations are while you're here, and as long as you meet those, we're on good terms. If you don't, then you might have to deal with management in a way that's unpleasant. Your choice, but that is the first message that gets sent if you are lenient. The second message that gets sent is the one that gets sent to the courthouse, because ultimately somebody's going to push you far enough to where you decide to take some significant action. If it becomes a legal action, then the message that you're going to be sending actually gets sent to the courthouse. And unfortunately, sometimes that message is one that can work in reverse of what you intend it to. What you want by taking action and claiming that you've been lenient in the context of perhaps a legal action is for the court to recognize, hey, listen, I've been giving them lots of chances. I've been compassionate, I've been helpful, I've been very willing to forgive and forget. But this particular tenant has pushed me so far that now I need the court's intervention. Well, unfortunately, what you want the court to take from that is, oh, okay, well, you've given them lots of chances, so I don't need to give them a chance. You've already taken care of that, and I'll go ahead and give you, the landlord, the relief that you're looking for associated with that tenant. Unfortunately, that's not what's going to happen, and that's not what we see in the courts. The court itself is likely to take the position, well, whatever the landlord has done in the past doesn't matter. It is up to me, the court, to give this tenant that one last chance. And so that months of effort that you put forth trying to, what you believe was help the tenant, is actually going to turn out to become a negative for you in a courthouse when a judge actually says, well, I'm going to give them one more chance. That's a potential message and a potential outcome that you're going to face when you finally get to the courthouse. Another message that it might send, which is even more difficult to overcome, is the one where the court decides that your actions, not the actual lease, are what is going to define the elements of the relationship between the landlord and tenant. I'll give you a very brief example. Your lease says they have to pay the rent, the tenant has to pay the rent on the first of the month. As we all know, there's a 9-day grace period, and so when the 10th comes around, if you haven't been paid, that's when you actually have a right to take legal action. But again, out of compassion and out of concern for a particular resident, you've decided that with this particular resident, you're willing to accept their rent on the 15th. So for several months, you accept it on the 15th. Eventually, the 15th doesn't become meetable by the tenant, and so they don't even pay by the 15th. You decide, okay, I'll give it to the 20th. And then ultimately, it gets to a point where, like I said before, you get pushed beyond your limits. And you've got a history of accepting the rent quite a bit of time after the 10th of the month. But when you've been pushed to your limit, you decide, hey, I'm going to go ahead and exercise my legal rights on the 11th because that's when I have a right to do so. Unfortunately, what the message that leniency can send to the court is that you've actually changed the terms of the lease. That rather than the lease, applying the lease, which says the rent must be paid on the first of the month with a 9-day grace period, the court can decide, you know what, you've changed the terms of the lease based on your actions, based on the tenant's payments and your acceptance of those payments on the 15th, as an example. We're going to conclude, the court is going to conclude, that the rent is due on the 15th, not the 1st. And as a result of it being due on the 15th, they've got a 9-day grace period. And so as long as it was paid before the 24th of the month, you, the landlord, don't have a legal case. That's really difficult to overcome, especially if on the 11th of that particular month where you took action, you had a notice to quit served, you've proceeded to the case, and now you're in a trial where the judge says, wait a minute, you changed the lease based on your actions. The message I'm getting is you wanted the rent paid on the 15th, not on the 1st, regardless of what the lease has to say. And so the court can conclude the lease has been modified and you, the landlord, don't have a case and don't have a leg to stand on. Not the kind of message you want to send. In fact, neither of those messages are anything that you want to send. I completely understand and recognize the need for providing excellent customer service and the desire to have people handling themselves in an appropriate way with mild encouragement and without the need for taking legal action. Just be very careful on just how lenient you want to be. You got to be very careful about the message that leniency sends both to the community and to the court, so that you don't end up losing the ability to manage the community and your residents the way that you'd like that to happen. Hope this helps. Thank you for joining us here at the Landlord Advocate, LLFtv. Look forward to seeing you next month. Have a great day.